Yeah, I'm Larry Tribe. I guess my official name is Laurence H. Tribe, and I'm the Carl M. Loeb University Professor at Harvard Law School and Professor of Constitutional Law. Well, I could go on for hours, but I'll try not to. I was born in Shanghai, China in October of 1941. My parents were Jewish refugees. They came originally from Belarus. My mom was actually born in Harbin. My dad had become an American citizen shortly before he met my mother. And when I was born in Shanghai, the war was about to break out. It was October 41. Pearl Harbor occurred, of course, on December 7th, and all hell broke loose. The Japanese occupied the area of Shanghai where we lived in the French Quarter. My father was interned as a prisoner of war by the Japanese because we were, of course, at war with them. It wasn't the same as the internment of the Americans of Japanese descent here. He was actually an American citizen, and therefore it was not so uncustomary that he would be interned. And I was too young, obviously, to know the difference. But as I grew up in Shanghai, I began to sense that he had done nothing wrong. It was just his identity. He was just an American. I kept wondering, why is he being taken away? That, I think, affected my sense of injustice and the importance of being able to correct it. When the Americans liberated Shanghai, the apartment next to ours was bombed to smithereens. I survived. My family survived. But I've always known that I was amazingly lucky. I mean, I was lucky to have survived. I was lucky that my parents were able to come to the United States when I was about 5.5. We moved to San Francisco. I grew up there. I went to public schools there. I was kind of a geeky, wonky kid, not the most popular on the block, partly because I spoke only Russian rather than English, and I didn't want to speak at all because I was embarrassed. So for a while I was the silent kid, which was not typical of me. When I was in, I think it was in kindergarten in Shanghai, my brother eventually sort of dug up the report card, which said that the one problem with Tribe is that he doesn't keep his mouth shut, talks to everybody, he's unruly, he doesn't take instructions, and his fine muscle coordination leaves something to be desired, as well as his musical sense. So they pretty much covered the waterfront. But actually it wasn't music, although I love music, or my fine muscle coordination that made a big difference to me as I grew up. It was mathematics and art. I mean, I loved painting until recently, not so recently, but until only a few years ago. I've done pastel boulderscapes, landscapes, seascapes, portraits, that kind of thing. And I'm very much a right hemisphere kind of person. My brain operates more diagrammatically than in a linear way, so that when I teach constitutional law, I'm always drawing colorful diagrams on the board. My hands are covered with red and pink and green and blue dusty chalk, and the kids tend to call them tribograms, and they take pictures of them with their iPhones, and I'm always amused that they find them so illuminating. At first, some kids are, especially Harvard Law students, are more linear, but I digress. So I grew up in San Francisco. I went to public schools. I was doing some advanced math work sort of by a correspondence course at UC Berkeley, so that I knew quite a bit of math when I went to Harvard College when I was quite young. I was 16. Probably a mistake. It was hard to get dates. I was really a kid, whereas these Radcliffe women, as they thought of themselves, were much too mature for me. And so I was always sort of a year ahead in one way and a year behind in another. I did well at Harvard. I ended up with a summa in mathematics, and I did some comparative literature, and I took one course in neurobiology that convinced me that I was never going to be a doctor. I had always told people when I was growing up, when I was a little kid, that I wanted to be a neurosurgeon, but when it turned out I couldn't make a Bunsen burner turn off properly, I realized that my future as a skilled lab technician was limited. I did do some graduate work in math. I took mostly graduate courses in math when I was at Harvard College because I had done lots of work in advance, and I took algebraic topology and algebraic number theory and algebraic geometry, all sorts of abstract stuff, as long as it didn't have any arithmetic in it. I was always bad at things like long division, multiplication. Addition I could handle, but subtraction was a challenge. I kid only slightly. I mean, my one not so good grade in elementary and secondary school was a grade that I will not even report here in I think it was 8th grade arithmetic. Anyway, so I went to Harvard. I graduated. I went actually into the Graduate School of Mathematics for a year on an NSF fellowship. It's a National Science Foundation fellowship. And I realized that when I was taking nothing but math and was not sort of leavening the loaf, or whatever the right image is, with a dose of humanities and literature or anything else, I was going to go out of my head. I mean, I also wasn't a genius at it. I was good. Obviously, you have to be pretty good to get a summa. But I wasn't a genius. And I thought that mathematics was a field where if you were not a genius, you were just not going to make a contribution to the world. And this will sound corny, but I felt lucky enough to have survived, to have gotten to America, where, I was really a corny kid. I believed in all of the freedoms that we have, and sort of the beliefs that I had then are very similar to those I have now about the fundamental importance of human rights. And I felt very fortunate to be in a country where I could experience them and where there wasn't a risk that we were going to be taken over by another country and then liberated by somebody else in a way that involved devastation. And so I thought that I ought to give back something. And what I could do, I concluded, in a way that was going to make a contribution, whether I was a genius or not, was law. I could do law, and that's an area where you have to be smart to understand it deeply. You have to have some creativity to be good at it. But even if you're not the brightest bulb in your generation, you can make a real impact. You can help people lead more fulfilling lives. And I was always interested, ever since I went to Harvard Law School, in that. I made a very quick switch from mathematics to law, so quick that I missed the application deadline at Harvard Law School. And I was feeling very bad that I'd have to go back and finish up my PhD dissertation. And I went to see I think the assistant dean in charge of admissions or something like that. And I said, is there anything I can do to increase my chances of getting in off the waiting list? Because that's where I landed, because I had applied too late. And he said, yes, there's actually one thing you could do. You could shoot everyone ahead of the line on the waiting list. And I said, that's very good advice. And will you be my lawyer? Anyway, just before law school semester began, in the fall of 1963, I got one of those old-fashioned telegrams. Most people who are listening to this probably won't know what that looks like, but it's this yellow piece of paper with funny-looking sticky stuff on it. And it said I was admitted to Harvard Law School off the wait list. So I was ecstatic. I went to Harvard Law School. And from the beginning, I loved the law. I didn't always go to my classes, I have to admit. I've never been one for always following rules. But I loved it. I loved the cases. I loved the combination of human stories and abstract principles. I loved the way the abstract principles were not absolutely determinate. They didn't always point to one answer. I found that a little frustrating at first, because as a mathematician, where I was used to precise proofs where you could put QED at the end of the page, it was not like that in law. And it took me maybe a couple of years to figure that out. And as a result, I didn't make law review my first year of law school. And back in the day, if you didn't make law review, your career looked like it was over. Today, there are a lot of ways kids can excel in law school. But back then, I really was devastated. I had just missed law review, and I didn't know what I would do with myself, because I really wanted to get a job where I could make a difference. But long story short, I did better the second year, better still the third year, impressed some of my professors like Louis Jaffe and Archibald Cox and Paul Freund and Milton Katz. They became great mentors. One of them in particular, a lovely man named Louis Jaffe, who was probably the great intellectual giant of administrative law, knew a wonderful judge in California, Matthew Tobriner, who became a kind of hero of mine for the kind of judge he was and the kind of legal career he had led in representing the employee side of labor cases. He selected me as a law clerk for the Supreme Court of California. I clerked there for a year. I loved it. He loved me. I got an interview with Justice Potter Stewart. I managed to get that clerkship. I got the great news that I had that clerkship almost the same day that my son Mark was born. It was one hell of a red letter day. And then I clerked for Potter Stewart. I spent time after that doing some work at the National Academy of Sciences as the director of something called the Technology Assessment Panel of the Committee on Science and Public Policy. It's sort of a mouthful, but it was just looking at the secondary effects, ecological, environmental, social, cultural, of technological change. I figured that even though I had had offers at that point to teach as an assistant professor at both Harvard and Yale, I was so fresh out of law school and I was just in my late 20s, I wanted to know something that the kids didn't know so that there would be, I wanted to be close to them, and I always have. I fool myself into thinking that I'm not really old, but you can see that I am. But the fact is that I wanted to have something to impart beyond just further reflections on the things they had learned in law school, and I thought spending some time on the interface of law, technology, public policy would give me that, and it did. When I started teaching at Harvard, which I ended up choosing over Yale, I taught a course in law and technology for a while. I taught evidence for a while because that combined some of my interests in philosophy, epistemology, mathematics, but I actually knew nothing about trying cases, and I felt I was cheating kids when I tried to teach them about the rules of evidence, because I would do it in a very abstract way that didn't really come to grips with the reality of what it was like to actually cross-examine a witness or prepare a witness for trial or take a deposition. And so after a few years, I dropped evidence, and I ended up where I have been ever since, teaching constitutional law, which absolutely brings me to life. I mean, it is the subject. People ask, why did you pick constitutional law? Come on. I mean, who, with a real opportunity to dig into a subject of law, would not want that to be constitutional law? It has everything. It has history. It has moral philosophy, the meaning of liberty, of equality, of dignity. It has legal technicality galore. It has precedent. It involves strategy, dealing with complicated human situations of the people who are affected by laws, and the human dynamic of complicated institutions like the U.S. Supreme Court. So I've loved teaching constitutional law and have taught it at Harvard for about 45 years. Speaking of President Obama, he is one of the students that I got to know when I was teaching. One of the great privileges of teaching constitutional law at Harvard and teaching a popular class that a lot of kids sign up for, more than can get into it, is that you end up with some very, very bright students. I taught John Roberts, the Chief Justice. I taught Barack Obama, who also became my research assistant for a couple of years, did wonderful, wonderful, brilliant work. I taught Elena Kagan, who was also my research assistant, Kathleen Sullivan. I mean, if I started to name them, the people that I didn't name would be rightly offended because they're all so impressive. And lots of my friends all over the country now, some of them you wouldn't recognize their names, but they're terrific people, and I've gotten to know them and I stay in touch with them after they leave the law school. Teaching law was what I wanted to do at that point. I hadn't planned to practice, although before I had the great good fortune of getting offers to teach from Harvard and Yale, I assumed I would practice at a law firm and combine ordinary practice with public interest work. But it turned out that I was able to teach, and I didn't do any of the practice. As I explained, I'd never done any trial work, so evidence didn't make sense. But at one point, after I realized that there hadn't been an adequate overall comprehensive summary of American constitutional law for something like a century, and that I'd better try to write one, which I would never have done again if I had realized what an unbelievably impossible task it was. I mean, I worked morning, noon, and night, day in, day out, every day, producing this tome, which has had a real impact. In any event, had I not done that, I don't think I ever would have gotten into practice, because that was cited by various people, and so people just assumed that I had experience in the Supreme Court, and I was asked to do a case in 1980, and it was an interesting and important case. I did it, and then I began a career as a law professor and a Supreme Court advocate at the same time. And I've had a lot of very interesting cases over the years, about 35 in the Supreme Court. And the combination of those cases, lots of pro bono activity on the side, occasional testimony before Congress, maybe 100 or so times in the House and Senate, a lot of advising for various public officials. It's been a very fulfilling career, combination of academics, public service, and sort of writing, teaching, litigating. There was only one gap as far as I was concerned, and that was I had never literally taken an oath to serve the United States government. I had taken an oath as a citizen because I was not a natural-born citizen. I was born in Shanghai. My father was an American citizen. My mother wasn't at the time. That meant I was not a citizen. I had to become one when I was about 10. But I had never, raised my right hand and said that I will serve the United States. And somehow I felt that was missing, and I wanted to do it. And because I knew the president, since he had been my research assistant, and I knew and admired the Attorney General, I hoped when the president was elected that he would have something interesting for me to do. And he did. He asked me to become the first senior counselor for access to justice, which was a made-up position. It had no budget. I had very little staff. It was a little bit frustrating that way, because you learn very quickly after you're in Washington that everything is about budget, staff, power, turf. So every time I got a good idea, somebody would look at me and say, well, it's a great idea, but this person over in the civil division wants to claim that as her bailiwick, and this is a good idea, but that's really the Civil Rights Division, or that belongs to the Solicitor General's office, or that belongs to the White House Counsel. So what I ended up doing was sparking lots of projects that involved collaboration with other parts of the government, some with Health and Human Services, some with the Labor Department, some with the White House Domestic Policy Council, some with outside groups, all of them involved with the fundamental unsolved problem of American justice, and that is its extraordinary inaccessibility. I mean, not only to the very poor, who basically can't afford lawyers, and without lawyers there's very little they can often do, but to the middle class. I mean, justice is largely unavailable, and by justice, I mean real, effective delivery of the things that you're entitled to. It's all very nice to have rights on paper, but making rights real, which actually is the name of the last chapter of the most recent book that I've written with a former student and research assistant of mine, Joshua Matz, making rights real entails actually having access either to courts and lawyers or to alternative forms of dispute resolution that are not stacked against you as the little guy confronting some behemoth corporate interest. So that was an interesting time. I think I got a number of things going that I'm pleased to learn are still going on. I was at the American Constitutional Society's convention today, and I met a few interns from Texas and Massachusetts and other states, and they're interns in, guess what, the Access to Justice office that I started a few years ago with no budget. It's still limping along, and it has made some useful, if marginal, progress. But at least there is an office in the Department of Justice that is called Access to Justice. I mean, one of my surprises when I worked for the government was that when people came to visit me, and they were chief justices of many states and state attorneys general and heads of public interest firms, they would want to have their picture taken, but not so much with me, with the sign above the door in my office, which said Access to Justice. It was a remarkable thing that until that point, there really was no central focus in the U.S. government and in the Department of Justice for that fundamental right, the right of access to justice. And now that it's there, although its jurisdiction to some extent overlaps that of the Civil Rights Division and the Civil Division, it's, I think, going to make a lasting impact. I think in some ways the most significant case that I handled as a lawyer in the Supreme Court or anywhere was the first case that I handled, and that was called Richmond Newspapers against Virginia. I hate to say that it was all downhill from there, but in a certain sense it was. That's a case that for the first time established as a matter of federal constitutional law that the press and the public have a right to observe and be present at the kinds of hearings, primarily criminal trials, that are traditionally open to the public, that you cannot simply exclude the public on some excuse that they would be embarrassed or that witnesses might be squeamish or that maybe somewhere along the line a secret would come out. I mean, you can block out people's faces if they need privacy. You can do various things, but you can't close the proceedings. It was a great case, and it established a principle that I think is vital not only to the rights of the accused, because this was not a case where the accused wanted the public to be present. On the contrary, he was very happy to have the proceedings closed. So was the prosecutor. So was the judge. They were happy to have them closed because after several missed efforts to convict him, there was some kind of deal whereby he was acquitted. And even the family of the murder victim didn't get to see what happened. They got to read a cold transcript, which was little solace later on. But it's really vital for the interests of victims, for the interests of the public generally, to know what's going on in these important trials that establish a great deal about vindicating principles of justice. So that was a great case, and I was very glad to have handled it. Another case, great in a very different and more limited sense, was a case that began in my own backyard. It was a case called Larkin v. Grendel's Den. There's this little pub in Harvard Square where people can have lunch and a drink. And I learned when I was teaching constitutional law that they couldn't serve drinks and were likely to go out of business because a nearby church had vetoed their liquor license. And I thought that was outlandish. How could a church be given the power to regulate the local economy? I mean, there were hard cases about church and state, like what kinds of prayers at a town meeting may or may not be allowed, or whether a menorah has to be next to a Christmas creche in order to make a display at Christmas sufficiently secular. But this was an easy case, and yet the law of Massachusetts had said churches have this power. So I worked with the student who had called it to my attention when he wondered why he couldn't get a drink with lunch, and I worked with Justice Stephen Breyer. Needless to say, he wasn't yet a justice, or I wouldn't have been able to work with him. He helped me put the case together. We argued that it violated both the antitrust laws because of the anti-competitive nature of the deals people could make as to whose liquor license would be granted and whose would be denied. And more important, it violated the separation of church and state, the Establishment Clause. And 8-1, in a wonderful opinion by Chief Justice Berger over solely the one dissent of Justice Rehnquist, the court said that this is a fundamental violation of the separation of church and state. Justice Rehnquist's dissent was based on the idea that since you can have liquor-free zones around churches and schools, you can do this as well, because after all, more kids can get a drink in Harvard Square if at least there's a chance of getting the church to say okay. But that didn't make any sense to me, and it didn't make any sense to the court, because the right that I was arguing for was not the right to get sloshed over lunch. It was the right not to live under the thumb of someone you didn't elect, the thumb of a religion that you may not believe in or belong to. So that was an important case. Of course, everybody would expect me to mention Bush v. Gore, but I think it's more interesting to know that cases that are less notorious can sometimes make a huge difference to the quality and the nature of our lives. Well, I doubt that Bush v. Gore will go down as the court's proudest moment. It's not so much that the Supreme Court got involved, although I have argued, and I think many people believe, that it had no business getting involved. It was a process that was already underway. The Supreme Court of Florida had mandated a recount of ballots in accord with Florida law. But okay, so the Supreme Court gets involved because it looks like a mess down there. It looks like the ballots are being counted in different ways in different parts of the state, maybe arbitrarily. Some people will remember the odd pictures of people holding up paper ballots to see if the little hole was punched all the way through or not in order to read the intent of the voter, an obviously difficult thing. And actually, in the end, 7 justices did agree that the process was so ununiform that it didn't satisfy requirements of equal protection. Now, that involved a very novel use of the Equal Protection Clause. It did not involve the use of the Equal Protection Clause to protect racial minorities or even to avoid discrimination along racial lines or along any other suspect line. No one thought that the process in Florida that was going on was anything but chaotic. That is, no one thought it was a deliberate scheme to deprive George Bush and his voters of the election. But put that aside for the moment. The real problem was not the court's 7-2 holding that a better and more uniform voting system had to be engineered. The real problem was the decision by the court, before it even heard argument in either of the 2 cases that are generally understood to come under the rubric of Bush v. Gore, one of which I argued and the second of which David Boies argued. But it was the decision by the court to halt the counting completely while the court took the case under advisement. Well, at that point, it really looked like the matter was over because the clock was ticking, the court was concerned about deadlines. In the end, the court decided 5-4 on the basis of a really bizarre reading of the relevant legal documents and the relevant laws of the United States and of Florida, that it's too bad that we can't have a uniform count of all the ballots and a uniform recount now that we're recounting, because it's too late. There are only a few hours until the deadline. Now, it was really months until the actual deadline. The president wasn't going to be inaugurated until months later. It wouldn't have been hard for the court to say, now that we've told you what's wrong with the method of counting the votes, do it right. But instead, the court took upon itself the task of calling a halt to a national presidential election, essentially determining the outcome by a mere 537 votes out of the millions cast in Florida, and thereby determining Florida's electoral vote and thereby determining the outcome of the entire election. For the court to do that really involved a deep problem, and the deep problem was this. The underlying rationale of the decision was votes should all be counted equally. Well, how equal is it if you stop counting before you've finished whatever counting process you're engaged in? That's an even more egregious and gross inequality than having slight variations between North Florida and South Florida. So I think the court did itself great disservice. Now, ironically, even though Justice Stevens and other dissenting justices predicted that the court's reputation would be badly tarnished by the decision, polls show that, on the whole, respect for the court has gradually declined over time, but not sharply in response to Bush v. Gore. And in fact, even now, when so many more people think the court is leaning conservative, in some senses of that term, more than liberal, it turns out that more Republicans than Democrats have a diminished respect for the court. Democrats tend to think it's not all that bad. So the court didn't do itself the kind of demonstrable institutional damage that I think many predicted, but I think it hurt its reputation, and I think it performed a national disservice by taking the power away from the voters. Early in my career, I had decided that it was really important to write what people have called a treatise on constitutional law. Thousands of footnotes, very elaborate summaries of the whole history of the thing, useful mostly for lawyers and especially for judges, because there was a big gap. After I did that, lots of other people wrote lots and lots of things about the court, the literature of constitutional law and of the law of the Supreme Court, not only through law journal articles, but through wonderful blogs like SCOTUSblog and others, is ample. So there are ways of of getting your hands on all the details of what's going on in the court. Journalistically, in terms of the general public, of course, that's missing because the general public can't immerse itself in all of those details. The general public gets a kind of, well, I have to say it, pablum. They get these caricatures about conservative versus liberal, activist versus restrained, completely false cardboard cutout pictures of what the justices are all about. You'd never know from hearing a lot of that coverage and reading a lot of it that Justices Alito and Scalia are at one another's throats often on the issue of what's the significance of the original meaning of the Constitution. In one case about violent videos, Justice Alito asks from the bench to one of the lawyers, I think what Justice Scalia wants you to answer is, what did James Madison think of video games? Did he enjoy them? I mean, these guys do not agree on how to interpret the Constitution, nor do the liberals agree on a number of issues. Justice Sotomayor joined what are widely regarded as the conservative justices in striking down a price control regime for drugs and pharmaceuticals in Vermont on the basis that it dealt with information and gave the government power over who could communicate certain facts to whom, and therefore violated the First Amendment. Sotomayor and Breyer disagreed strongly in that. And when I notice things like that and realize that to an ordinary person in the public listening to all of this stuff about how we're certain that the court is going to be 5-4 on this because there are 5 Republicans and 4 Democrats, or the court is leaning very strongly conservative on something else, I realized that there was a gap. And there was a gap that hadn't really been filled. There are terrific books by Jeff Toobin called, a book like The Nine and The Oath that give a colorful picture of battles inside the court, but they're not so connected with the legal principles that the court is articulating and that shape our lives. So you can get the legal principles if you want to take a little time out, get a law degree, become a constitutional law expert. You can get the caricature if you just want to read the morning news. You can get interesting drama about the personalities if you look at some of the books that are written, but a book that brings it together in a way that is accessible for the public seemed to me to be badly needed. And the reason it matters for the public to care about all of this is that the Supreme Court changes our daily lives. It makes a decision and it affects whom we can marry. It makes another decision. It affects whether we can own a gun or whether the people in the shopping center where we go will have guns. It makes another decision. It affects whether the president can take the nation to war. I mean, these are momentous decisions. They shape our lives. In a democracy where we're supposed to be self-governing, we ought to at least be tuned in to what's actually happening and not just caricatures of it. And so I thought I could help do that by writing a book that was fun, that was accessible, that people like Doris Kearns Goodwin would say are a joy to read. That would help entice people to read it. And then how would they use that knowledge? Well, they would use it partly in figuring out what the court's decisions mean to them, where the future is likely to go, but also when the next vacancy occurs on the court. It might make more sense for people to focus on what really matters about the justices who are nominated by presidents and who are either confirmed or rejected by the Senate. What are we looking for? Are we looking for a person who fits some stereotype of a, quote, strict constructionist or an originalist or an activist? Or are we looking for something about the worldview, the outlook of the person, the way the person understands the Constitution based on that person's entire life and history? And I think a more informed public means a better appointment process, means a more intelligent confirmation process, means a court that is more responsive to the evolving American narrative about our Constitution. But once I got the idea that a book like this was needed, I wondered how I would go about doing it. I was in the process of working with a really brilliant research assistant named Joshua Matz, who was my top research assistant at the time, and who was also going to help me put together a course for undergraduates, Harvard College kids who wanted to learn about not details of constitutional doctrine, but thinking about the Constitution. And we worked together so seamlessly. I mean, there was a wonderful generational difference. I'm in my 70s, he's in his 20s. He sort of knew the lingo of the generation I was trying to teach better than I did. He was in touch with them. I was in touch with what I thought was a different array of issues and understandings. And because we worked together so well, we thought it might really be fun to try to write a book like this together. Well, it was fun, but it was unbelievably hard. I mean, it was hard partly because the subject is hard, partly because making it seem easy and understandable without talking down to people is a real challenge, and partly because I was busy teaching full-time and he was busy clerking full-time. He was clerking for Judge Etkin in the Southern District of New York, then for Judge Reinhardt, not thought to be a person who leaves you much free time in your life in the Ninth Circuit. He was about to go off to clerk for Justice Kennedy next year. We wanted to make sure that the book got done before he started clerking for Justice Kennedy in July of 2014, because it was absolutely critical that no one suspect that any of the information in the book was somehow inside information from within the Supreme Court. So that gave us a much more genuine deadline than most people have. I mean, when the publisher would occasionally raise the idea that, you may need another month on this chapter or another week on that one, we would typically say, well, there's only 24 hours in the day. I typically don't sleep much anyway. But one thing that has to happen is this book must be out by June 3rd. And by God, it came out on June 3rd. And the process of working with Joshua Matz on it was great. We would exchange drafts. We would exchange emails. He was on the West Coast. I was on the East Coast. He was a little bit surprised that I would send emails at 3 in the morning. I was a little bit surprised that he was still asleep at 10 in the morning, but then I kept forgetting that's 7 in the morning out there. And I'm sure we must have exchanged 100,000 emails and Word documents, and finally the book came together. It came together in a way that I'm very happy with, and I think Joshua is as well. Well, other books, I mean, there are so many different ones that I'm not sure what to say. Some books take 2 or 3 main cases and focus on them, like Obamacare, gun control, and perhaps Citizens United. And they try to tell a story about each one, how the lawyers found the clients, how the case found its way through the courts. Some books tell a story about a particular personality clash, Obama versus John Roberts, beginning with the flubbed oath of office, in which I felt so strange here. 2 of my students in constitutional law, and they aren't even getting the oath of office right. But big secret, I don't think I ever asked them to memorize the oath of office. This book is organized around a kind of different principle. We wanted to touch on every major area that the Roberts Court, each court being named after the Chief Justice, just somewhat arbitrarily, that presides over the court during that time. Roberts became Chief Justice in 2005. There were lots of really important cases during the period from 2005 to 2013. We didn't want to leave any of them out. There were important cases dealing with free speech and politics, important cases dealing with, of course, Obamacare, but not each in isolation. Obamacare, just for example, is a case not only about the limits of federal power to regulate people, but also about the limits of federal power to tax people, and about the limits of government power to make people do what's good for them generally. And that connects to principles of libertarianism, economic liberty, that are important in other areas of the court's decision-making. So when we would take a case like Obamacare, we would embed it in a chapter. In that one, I think we called it the healthcare cases, Liberty on the Line. We would talk about all of the interconnections that the existing literature just didn't talk about. And in the chapter on Citizens United, which we separated from the chapter on free speech, we would talk about the relationship between money, political power, and free speech, and the dangers of government deciding who may speak and who may not. In that one, we called it Citizens United, Follow the Money. The point is that each chapter took a case or 2 or 3, not so many as to become hard to keep track of, the most important cases of the Roberts Court in every area, from free speech, through equality, through gun rights, through federalism, through access to justice, and then an important additional topic that none of the books talk about, the topic of bargaining away your rights. It's something that the court has begun to grapple with. You know, there are a lot of ways the government can get people's rights. It can put a gun to your head, and it can coerce you, perhaps into confessing, perhaps into pleading guilty. There are limits on coercion. But what if it just tempts you? What if it just bribes you? Are there limits to how government can bribe you? That, it seemed to me, was an important thing that none of the popular writing about the Supreme Court examined carefully, and something that the Roberts Court has paid a lot of attention to in some interesting cases, including cases about AIDS, about prostitution, about all sorts of subjects that are kind of intrinsically colorful and interesting. But the frame of it all was the inadequacy of caricatures about the court. That's why we call it uncertain justice. Everybody seems certain of their own views of the court. You know, there are these people who are certain that people on the court are just politicians in robes. There are others who are certain that politics doesn't make any real difference. There are people who are certain that they have a way of predicting decisions. We are uncertain, and we think uncertainty is inherent in the nature of what the court does and the problems that it confronts. And we think that uncertainty is not necessarily a terrible thing. We think it can be cleared up to some extent, but we think it is the uncertainty that people need to understand. And so we begin and end the book by talking about the nature of uncertainty in the law and, frankly, in life generally. Well, the Obamacare case was an odd mix of a case that began with broccoli, when everybody was saying it was a wonderful image. Do you really want to have a government that can tell you you've got to eat your broccoli? Of course, Obamacare didn't make anybody eat his broccoli or buy her broccoli. It just said if you're going to use health care, and everybody does, you've got to pay for it with insurance. But there was a powerful sense in which forcing people to buy a product they didn't want to buy seemed un-American. It seemed an invasion of liberty. But the existing legal principles about invading liberty were not very sturdy. That is, the government can make you vaccinate yourself in order to avoid the spread of a disease. Government can make you wear seatbelts. The state of Massachusetts can force people to buy health care. So what was special about Obamacare that made it offensive? Well, it turned out that what was special in some ways was that it came from the national government rather than the states. And so there was this powerful developing argument that the federal government has to be cabined and limited in various ways. And I thought it pretty clear at the outset that the court's approach to this was going to distinguish between two fundamental uses of federal power. A coercive use that actually makes people do things like buy health insurance, and an incentive use that basically nudges people toward doing it by simply increasing their tax liability if they don't. And it turns out that that's the way Obamacare managed to survive. That is, I thought and said publicly, both before and after the oral argument, that it was likely that Chief Justice Roberts would cast the decisive vote to uphold Obamacare, not as an exercise of a rather frightening national coercive power, but as an exercise of a mild power, he thought of it as mild, to increase people's tax liability so that the burden they are putting on the system is covered by the taxes they pay if they are not going to buy insurance. That is, in the way the oral argument developed, it became a case of the federal government giving you a choice, either buy the insurance or pay more tax. And once it was put that way, I was predicting that Roberts would render the final decision based on the taxing power, and indeed he did. I don't think it was that much of a surprise if you think of the way he evolved as a student of the law. At the same time, there was this other half of the case in which 7 of the 9 justices, including 2 of the more liberal justices, Breyer and Kagan, held that the federal government does not have the power to force the states to accept its expanded Medicaid program, even though it's going to subsidize that program, almost to the tune of 95%. When the Obama administration lost that part of the case, that is, the federal government can't use its club of threatening to withdraw all of Medicaid as the penalty for a state that doesn't go along with expanded Medicaid, it sort of looked to a lot of observers as though Roberts was being a master politician. He was giving one to the Republicans, no Medicaid coerced on the states. He was giving one to the Democrats. Your purchase mandate will be upheld. Whereas I saw the two pieces as entirely consistent, and we explain in this chapter why they are. They're both about an aversion to coercion. They're both about the idea that when the government can achieve its purposes by nudging people, by saying, if you don't do it, we'll increase your tax a bit, or we will deprive you of something, but not threaten you with imprisonment. Both parts of the case suggested that when the government stops short of coercion and uses inducement, financial inducement, it's more likely to succeed. Now, in the book, we explain what are the limits of that principle. But what was fascinating about Obamacare is that what would otherwise have been a dramatic defeat for the leading effort by this administration to achieve something that prior administrations had tried for 100 years to achieve became instead a decision that put the ball back in the political court of implementation. Of course, the program was botched in its initial implementation, but now it seems to be on its way. And it was an example of the court acting not in what some people regard as a purely political way, but in a way that responds to principle. Well, the Roberts Court is deeply divided, as is the country, on the subject of race. And we talk in the book about how 4 members of the court seem to think that our difficult racial history is behind us, and that, as the Chief Justice put it, all we need to do in order to get past the problems of race is to stop making race a big deal. We have to stop using race as a basis of any government action. Famously, he said, the one way to stop discrimination based on race is to stop discriminating based on race. Other members of the court are deeply convinced, every bit as deeply, that we're not anywhere near the goal yet, that there's still a lot of hidden and unconscious race prejudice, that we have miles to go before we sleep. The justices who tend to believe that we are almost there have been on the ascendant. And most recently, and I think most unfortunately, in a case from Selma, Alabama, when the court invalidated the provision of the extraordinarily important Voting Rights Act of 1965 that required jurisdictions that had previously been adjudicated guilty of severe race discrimination in voting to submit their proposed changes in voting schemes to the government for approval. When that was ripped apart by the court, it left the law of racial equality in a very difficult state. I mean, Justice Ginsburg, I think, was right when she said that for the majority to say we have achieved so much that we don't have to continue doing it is like saying, this umbrella has kept me dry in a storm, so I can now get rid of it and toss it away. But on many other issues dealing with race, the division is not yet resolved, partly because Justice Kennedy, very much in the middle, is unwilling to go either all the way with the Chief Justice and some on his side on this issue by saying we have to just disregard race. Nor is he willing to go with Breyer and Sotomayor and Kagan and the more liberal members of the court in saying that when race is used in a benign way to integrate rather than to segregate, it should not be so strictly supervised by the Supreme Court. Affirmative action, that is, attempts to integrate rather than segregate in race-specific ways, is teetering. It's not dead, it's not exactly alive, it's on life support, and in the book we talk about why the decisions have come out the way they have and what the future seems likely to hold. I think the one area where the court has really spurred and been party to a major cultural and social revolution in legal understanding is with respect to gay rights. One of the cases that I argued and lost in 1986, a case about whether the government can punish people for having oral or anal sex, particularly if they're of the same sex, but the law that the court upheld in that case, in Bowers v. Hardwick, drew no distinction. It said oral and anal sex between consenting adults in private is illegal. When I took that case, I was pretty clear that I wouldn't win, but I wanted to generate dissents that would become the future, because I thought it was clear that laws of this kind, even though they were technically about anatomy and not about sexual orientation, in fact were the way that people used to marginalize lesbians, gays, and bisexuals, because they could easily say, well, look, the only way they can satisfy their physical cravings is by having oral or anal sex, and that's a crime, therefore they're criminals, therefore it's okay to exclude them from various public benefits, it's okay to deny them the right to adopt kids. It was symbolic and it was central to the second-class citizenship of some of our own closest relatives and friends. And when that dissent became essentially the majority opinion in a case in 2003 called Laurence v. Texas, when I was in the court as counsel for the American Civil Liberties Union and Justice Kennedy delivered the opinion, it was a glorious moment. It was a glorious moment because the court said that Bowers v. Hardwick had been wrong from the very day it was decided. And it was not enough to simply strike down these laws when they drew distinctions between same-sex and opposite-sex intimacy. You had to get rid of them entirely in order to avoid the symbolic indignity to the LGBT community. In that decision and in another one striking down a Colorado constitutional amendment that made gays second-class citizens in another way, the Supreme Court made enormous strides analogous to those that it had made in the 1950s with respect to race, culminating in Brown v. Board of Education. Probably the most important of those decisions to date is the decision striking down the most important part of the Defense of Marriage Act. In that case, Justice Kennedy, joined by the four often described as liberal justices, struck down the provision of federal law that said even if you're legally married in a state, and right now there are, I guess, 19 states that either by the state's own laws or by judicial decision will allow same-sex people to marry. Even if you're legally married under the laws of California or New York or Massachusetts, as far as the federal government is concerned, if you're not a man and a woman, you can't be married, and there are about 1,000 benefits that you will be denied. When the Supreme Court struck that down, not only because it wasn't part of the federal government's business to second-guess states in that way when they expand rights, it'd be a different question whether you can appropriately overturn the states when they constrict rights. Not only was it an excess of federal power, it was an indignity and a denial of liberty and equality to same-sex couples. To tell couples that they can't be married even though they are the same as other couples in the same state, and that their kids can't say that my mom and dad are married, and that their kids can be ostracized, is a fundamental indignity, and it's only a matter of time until the Supreme Court says so. And we suggest in the chapter that the court has left a path of exit. It hasn't absolutely committed itself to that result, but now that state after state has had a federal court ruling and some state court rulings saying that the ultimate meaning of equality and liberty and dignity in our constitutional system is that people, regardless of their sex, should be able to marry whom they love, I think it's really quite clear that the Supreme Court will move in the same direction. In the chapter on Citizens United, we begin with Stephen Colbert. How could we not? I mean, Stephen Colbert was a formidable adversary of the Supreme Court. They were outmatched. They came to this gunfight with barely a knife. And he did a good job of caricaturing the court, making it look like the court was holding that corporations are people. You know, we know that they don't cry, they don't love, they don't make love. How can corporations be people? And that money doesn't influence politics. It's easy to make fun of the court and to make it look like its invalidation of campaign finance reform was simply an exercise of sort of preference for oligarchy and for wealth and for corporate power. But in the chapter on that subject, we show that it's way more complicated than that. That even if you don't regard corporations as people, and frankly I don't, that there is a danger of having the government silence a corporation when it wants to spend money on an anti-Hillary movie, or for that matter, an anti-Sarah Palin movie or an anti-McCain book. There are dangers in having the government decide who is entitled to speak and who isn't, who's speaking too much, how much speech is exerting too much influence. I mean, those are things that are scary. It's not a happy thing for democracy that people with power and wealth can just multiply that power and wealth by using it to gain access and influence. And we talk a lot about that in the book. But it doesn't follow that giving government the power to tune down the speaker on the very wealthy is the solution. And it, in fact, is part of a very strong tradition in our constitutional history. Although it doesn't go back to the very beginning, it's really something that has been given life only since the 1940s. It's part of a very strong tradition that we are properly suspicious of the government when it tries to decide who is influencing discourse too much. I mean, if a spaceship were to suddenly land in Lafayette Park across from the White House and start influencing citizens on how to vote, and if the government were to pass rules saying spaceships aren't people, they can't, even though they've gotten their hands on money, they can't spend it on speech because we don't want them to influence us, we would say that's government censorship. And it wouldn't help to have a constitutional amendment saying spaceships are not people. So that's what we do with Citizens United. We show it's a much more interesting and difficult and fascinating problem than most of the people who pontificate about it seem to think. Well, one of my early experiences when I was clerking at the Supreme Court was to work on an opinion in a case called Katz versus United States, where the Supreme Court said that the Fourth Amendment protects people, not places. And what it meant by that is that even if the government doesn't sneak inside your house or stick a wire inside your lapel in order to overhear you, if you have a justifiable expectation of privacy and they are violating it, then that should be subject to constitutional control, typically under the Fourth Amendment of the Constitution. That decision was important in connecting the right of privacy to communication. What the court said was that if the government gets everybody to expect that Big Brother is always listening, the way some of us now with the NSA metadata program have begun to expect, then people will not feel very free about their communications. Communication will be inhibited. Speech is involved here, the First Amendment as well as the Fourth. And a few years after that decision, the court, I think, made a big mistake when it said, with respect to a particular little new technology called the pen register that could be attached to someone's telephone and could let the government know, let Big Brother know every number that was being dialed. When the court said, hey, that's not private, you don't have any expectation of privacy there, you've already let your phone company know the number you're dialing, so it's no big deal to have Big Brother know. That was a big mistake. Justice Stewart, for whom I clerked when we worked on the case of Katz versus the United States, the case involving the Fourth Amendment protecting people, not places, he dissented in that case. That's what's coming before the court now in an issue involving cell phones that's going to be decided this term. And in the metadata collection issues of the NSA. It's true that when we have an information service provider with our smartphone, we know that it gets information about all the websites that we're visiting and all the emails we're sending, but it doesn't follow, or it shouldn't follow, if free speech is to remain the rule in this country, that the government knows it all and that we should be entirely satisfied to have the government learn it. The court has had these wonderful cases in recent years that we discuss, humorous cases and interesting cases, scary cases about DNA collection, about attaching a GPS to your car. That's another good example of why it was important to write the book. People tend to assume that liberal and conservative sort of line up in the same way on different issues. Well, it turns out that on privacy, Justice Breyer is considerably to the right of Justice Scalia. And it turns out that when the court was grappling with the case in which the FBI attached a GPS to the bottom of this guy's Jeep and followed him for a month, all 9 justices had no trouble coming out with saying that, hey, that's a search and it needs government regulation, it needs to be subjected to the warrant requirement. It was clear from the beginning of the argument that it would come out that way. I mean, Roberts basically said to the hapless lawyer for the government, do you mean to say that if you were to attach a GPS to my car, you could follow me or any of my colleagues for a month? And the poor guy had to say yes. He couldn't have said, oh no, Your Excellency, you are immune to the laws of the Republic. So it was clear they were going to come out that way. But how and why? Scalia came out that way because the GPS was attached to the guy's property. It was as though the Fourth Amendment protects property rather than people. Alito said, what are you talking about? It doesn't matter that it was attached to the Jeep. It wouldn't have been any different. It might have been worse if it had been tracking him from a remote location. And then they had this wonderful jousting back and forth in which essentially Scalia says, but there is a fundamental principle we want to preserve. We want privacy to be as strong now as it was in 1791. And Alito basically says there was no analogy in 1791 to the global positioning device. And Scalia says, sure there was. Just imagine a guy in a carriage or in a coach and a constable hiding and following him around and figuring out where he's going. And Alito basically says it would have to have been an awfully large coach or a really tiny constable, or at least a constable with enormous fortitude and patience. Well, it's that kind of jousting over new technology and how the law should handle it that figures over and over again in our discussion of privacy. Sotomayor seems to be about the most tech-savvy of the justices, although Kagan isn't far behind. She tends to rely a little more on her law clerks. Sotomayor argued in this GPS case that it's the doctrine of that old pen register case that now perhaps needs to be reconsidered. We need to reconsider what is called the third-party doctrine, the doctrine that says that when you turn your information, your private information, over to someone else, like the phone company or your information service provider or Google, that you automatically take the risk that the government is going to learn it. So the court is grappling with these new technologies, and the justices have very different attitudes toward them. In one public address, Justices Ginsburg and Scalia, who often disagree but are great buddies when it comes to opera and sort of general conviviality, we're talking about the inevitability that the NSA's program of collecting all the emails that any of us send, or at least the addresses to which we email and the numbers that we call on our cell phones, they had a very different attitude toward the prospect that that issue would come to the court. Justice Ginsburg essentially welcomed it. She said, we have to grapple with this. It's important to people's privacy. That's important to people's control over their whole lives and who they are. And Scalia said, it's really a great shame that we're going to have to grapple with that because we don't know squat about high technology. He even in one case involving genetic manipulation concurred only in part with an opinion by Justice Thomas on the ground that he didn't really understand the science. So science and technology is going to figure very importantly in the future of how the court grapples, not only with privacy, but with other rights.